Good afternoon, everyone. I think we're going to go ahead and get started. Hi, Whitney. Good afternoon.
Hi.
So welcome to our webinar. It is a 10-question quiz looking at current events in legal ethics. We all need our ethics credit, so very excited for this one. This has been approved for 1.2 ethics hours in Missouri, 1 hour in Arkansas, and 1 hour in Kansas. All of those are ethics. So good afternoon. I'm Jen Matthew. I am the director of ADR for Alaris. I just have a couple of housekeeping items and we will get to the reason we are here today. For those of you who are seeking Kansas credit, we do have 2 poll questions during the webinar. So please answer those questions and we'll usually record that information so we can get that from you later. And then next month, we are presenting a CLE on early neutral evaluations. If you're wondering what that is or you've never even heard of it, please tune in. Bob Sullivan, who's one of our neutrals for Alaris, will be presenting that on April 22nd, and that is from 12 to 1. You can find the registration is up on our website, which is alarisadr.us for that one and all future webinars. So after the webinar today, you will receive a survey. We are always looking for ways to improve, and we will share any comments you have or thoughts with Whitney if applicable. And then we'll also send a certificate of attendance. We get asked about these a lot, so please be patient. We try to get them out within 48 hours. So by tomorrow afternoon, you will receive your certificate. If you are joining us by phone only, looks like there's one of you at least, please send an email to CLE@alaris.us so we can ensure that we know who you are instead of just a phone number. And then lastly, if you have any questions, Whitney has a lot of content to get through, but she has graciously agreed to answer questions during. So please feel free to use the Q&A link and I'll monitor those, Whitney, and jump in if needed. And if not, then you know you had a perfect presentation. So it is my pleasure to introduce Whittney Dunn this afternoon. She has been with us. I think this might be your 3rd time presenting. You're very insightful and very professional, so we appreciate you. I think you know that, but thank you. So Whitney is a risk manager at the Bar Plan, and she's a national speaker and presents to hundreds of lawyers annually on ethics, professionalism, and malpractice avoidance. When she's not presenting, she provides one-on-one ethics guidance and law practice management assistance to the attorneys in the states where the Bar Plan provides malpractice insurance, Missouri and Kansas being 2 of those. So I asked Whitney for one fun fact today, and she said that for the past year or so working from home, one good thing for her is she's been able to go for walks every day with her husband, which has enabled her to be healthier both physically and mentally. So I think it's a really nice fact. So I wanted to share that. So I'll turn it over to you, Whitney. Thank you.
Thank you so much, Jen, and thank you to everyone for being here with us today. Let me get my PowerPoint started, and it should be now up on the screen. So let me know if for some reason no one is seeing that.
Looks great.
So awesome. Thanks, Jen. So we're going to do a 10-question ethics quiz. Now, if you've ever attended one of the Bar Plan seminars before, you've probably seen our ethics quizzes. Normally, I would read all of them. You know, if we were in person all together right now, I would read all of the questions and let you take notes about which one you thought was right. And then I would go into all the answers and you could kind of grade yourself. But there's no reason in this virtual format. You know, I can't hand out a gift card to the winner or anything like that. So what I'm going to do is I'm going to read the question and give you maybe a couple of seconds to pick which answer you think is right. And then for each question, we'll just dive right in. So our first question. During a dissolution representation, your client sends you electronic copies of email correspondence between adverse spouse and various third persons, including adverse spouse's attorney. Your client obtained access to the information through the spouse's email account using the spouse's username and password, which the spouse never changed. Your use of this information, A, violates rules 4-4.4a and 4-8.4c if the information was inappropriately or wrongfully obtained. B, is permissible because the adverse spouse could have no expectation of privacy as to the information. C, requires you to first determine whether Rule 4-1.6 permits you to reveal your client's conduct in obtaining the information. Or D, is permissible because adverse spouse failed to take reasonable steps to protect it. And a quick note as you're thinking through and picking which answer you think is correct. The references in this presentation are going to be to the Missouri rules. That's why they all have the 4- in front of them. But as you probably are aware, the rules of professional conduct are similar from state to state. And a lot of the principles that I'm discussing are identical in Kansas and Arkansas. But if you do have any questions about differences that you'd like to discuss with me afterward, my email address is in this PowerPoint, or you can get that information on the Bar Plans website. So hopefully you've picked the answer for this one that you think is correct. And I will tell you the correct answer is A. Your use of that information would violate Rule 4-4.4a and 4-8.4c if the information was inappropriately or wrongfully obtained. And this comes from a Missouri informal opinion, actually the first Missouri informal opinion that was published in 2019. And that opinion looks at the requirements of the rules of professional conduct and specifically looks at Rule 4-4.4, which talks about duties to third parties. And the comments to this rule say that an attorney's responsibilities to a client absolutely require the lawyer to subordinate the interests of others to those of the client. Definitely, that's clear. But that doesn't mean that a lawyer can just outright disregard the rights of third persons. And a couple of those rights of third persons that can't be disregarded are included here in this comment. Legal restrictions on methods of obtaining evidence from third people and unwarranted intrusions into privileged relationships, such as the attorney-client relationship. So that's essentially kind of what's happening here. Your client has not, it's not like this client stumbled upon this information. Your client used the spouse's username and password to access confidential communications between that individual and that individual's attorney. So it would violate 4-4.4a and 4-8.4c, but typically when I'm talking about situations like this, be it a client brings you information that they pulled out of their spouse's email account without permission, or maybe it's something that they stumble upon, or maybe you accidentally are sent something by the other side. And everyone's question is always, first of all, what do I have to do? And what can I do with it? This was obtained. Can I use it? Can I read it? Do I have to destroy it? Do I have to send it back? Et cetera, et cetera, et cetera. So what we see in comment 2 to the rule is that the rule explicitly punts these questions. It says it's not addressing the legal duties of a lawyer who receives a document that the lawyer knows or reasonably should know may have been inappropriately obtained by the sending person. We don't have an answer to that from the rules of professional conduct, but we do have a couple of opinions of attorneys either being disciplined or sanctioned for certain conduct that we can look at as kind of a guideline. And one of those is In re Eisenstein. This is a 2016 Missouri case. In this case, the fact pattern is essentially this. The client brought to the attorney a large number of things that the client had obtained by getting into spouse's email. And the attorney didn't, first of all, was found to violate 4-4.4a because there was evidence that was used that was obtained in a way that violated the rights of the person. Also was found to violate 4-8.4c, which is engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation. Also found to violate D, prejudicial to the administration of justice. And another thing that this attorney did was this attorney did not disclose the fact that he had any of this information. He didn't produce any of this information in discovery pre-trial when there were questions about, on what information do you intend to rely? Those types of things that are typically sent in requests for production. And on like the second day of a trial, in order to impeach the witness, he just pulls that out. Well, I have here an email from you to your attorney. So he was found to also violate 3.4a, which is unlawfully obstructing a party's access to evidence or altering, destroying, or concealing a document having potential evidentiary value. So what not to do is, okay, my client brought me this. I poured over it. There's great stuff in here. I'm going to sit on it. I can't wait. This is going to be a trial. Gotcha. That's what's not to do. There will be discipline there. But this is a Missouri case where there were sanctions that were found to be necessary against an attorney by a trial court, and the attorney appealed that. And this case is a little more of a what to do, give you some helpful tips about the right way to handle this situation. Actually, similar situation, client brings in stuff they've gotten out of spouse's email. Trial court said the lawyer had knowledge of the content of the email, continued possession rather than deleted it, intended to use the emails to hurt the adverse spouse, and failed to discourage the client from sharing the emails with the adverse spouse. So the trial court said essentially what this attorney did when the attorney received the documents was wrong. But the appellate court disagreed. What did the attorney actually do? Well, the first thing that the attorney did was they consulted with an ethics attorney, someone who was an expert in the field of legal ethics, to ask, what can I and can't I do here? That's the first thing the attorney did before taking any action. Then the trial court says that the attorney wanted to use the emails or had some type of use. And the appellate court said, well, actually, when you use the word use, you're really just referring to the attorney did read through the information after receiving it and after checking with an ethics expert first, and put some Post-it notes on some particular emails, but didn't actually go ahead and use that information in the same way that the attorney did in In re Eisenstein. Didn't use it as a gotcha or pull it out or try to get leverage with it or anything along those lines. The attorney did read it. But the use is questionable, the appellate court says. And so what we see here is that actually, if you find yourself in this situation, the best thing to do is consult with, first of all, I recommend consulting with Legal Ethics Counsel's office if you're a Missouri attorney, the Office of the Disciplinary Administrator if you're a Kansas attorney. And I apologize, I'm not sure what the office is in Arkansas, but whatever the similar office is in Arkansas, consult with that level of ethics expert, so that then if you find yourself in a situation where someone is alleging what you did with that information was incorrect, you can point back to and say, hey, I did my due diligence. I checked with an ethics expert, actually the preeminent ethics expert in our state, and I followed those guidelines to a T. That's the first thing that you should absolutely do. But another thing that is even better is not finding yourself in this situation in the first place. As a risk manager, that's the world I live in. How can we prevent you from having a client walk in with this folder full of, inflammatory information that you now are balancing all of these duties that you have to clients and third persons? Instead, do a couple of things. First of all, talk to your client about this situation. Explain to them that doing this will not give them a leg up, that you are bound by certain ethics duties that will require you to, disclose the fact that you have this information to the other side, that will require you to not use some of the information in the way that the client might think. So let them know they're not actually helping their case if they do something like this up front before they think about doing that. Also, have a conversation with your client and get their buy-in to make an agreement with opposing party and opposing counsel about what would happen if something like this occurred, or go farther than that. What would happen if an email is inadvertently sent, not this situation with the improper access, but is inadvertently sent, say, by opposing party. They meant to send it only to their attorney, but they sent it to an email chain that maybe included you on it also, but it's, confidential information that they intended only to share with their attorney. What will happen with that? Well, talk about those things up front. Get an agreement in place with the other side so that you can have some assurances that if that happens with your client, what's going to go on. It can help you counsel your client about the consequences of things like that. And it can also help you reinforce with your client how important it is to be very careful when sharing confidential information. One of the things we recommend is to, instead of that boilerplate confidentiality language that a lot of attorneys have under their signature block, we recommend if you are actually sending something that is privileged or confidential, putting a label at the top of that email and only labeling the emails of which that is a fact. Don't add that into an email that you send out to Jimmy John's to place a suborder for your lunch and learn, webinar at the end of the week. Only put it on information that's actually confidential and put it at the top so someone might actually read it before they read everything that's in the email, and give it to the client so the client can do the same. That's another way to make sure you're protecting the way that information flies back and forth electronically. The inadvertent disclosures are probably even more of a question mark and even more likely than this type of unauthorized access and inappropriate access that we see in this question here. Now, I did see a few things pop up, and I see a little orange pop up. I'm assuming because Jen didn't pop in, we don't have any questions, but if I'm wrong about that, Jen, pop in, no problem. And if not, I'll just go on to the next question. Question 2, you represent employer defending against a wrongful discharge claim. Employer believes the employee engaged in criminal conduct during employment, and the evidence of that conduct has been destroyed while in employee's lawyer's possession. You may, A, threaten to refer employee to the prosecutor unless employee drops the civil suit. B, threaten to file a disciplinary complaint against employee's lawyer unless the client drops the civil suit. C, neither A nor B. Or D, B, but not A. Lots of letters going on here. So take a second to pick which one you think is correct. And the correct answer is C, neither A nor B. So this is another Missouri informal opinion, the second one published in 2019. And what we see here is that it may technically be permissible to do A, which was threatened to refer the employee to the prosecutor unless the employee drops the civil suit. That may technically be permissible. However, in order for that to be permissible, there are quite a few things that have to occur, and you see it set out here in this informal opinion. One of them is the attorney has to actually intend to refer the matter to prosecution if it's not dismissed or settled. That can be an idle threat in order for it to be an ethical one. Also, the conduct underlying the alleged criminal defense has to be related to the civil action, and the use of the threat itself cannot be a crime. We'll talk about more on that here in a minute. Also, the attorney has to have a non-frivolous good faith belief based in law and fact that the employment-related conduct was unlawful, and the attorney's use of the threat can't be something that lacks no substantial purpose other than embarrass, delay, or burden plaintiff. So you technically can do it, but there are a lot of steps that have to be met along the way. And I want to point out, as it does in this opinion, some jurisdictions consider the use of a threat to file criminal charges to gain leverage in litigation to be a violation of the rules of professional conduct, regardless of the circumstances. Missouri is not one. Kansas is not one. I'm not sure about Arkansas, but I know for a fact that Illinois is one. So if you're an attorney who's licensed in Missouri and Illinois, you could potentially run afoul of the ethics rules that govern your conduct in one of the states where you're licensed, even if it is technically permissible in another state where you're licensed. So there are a lot of reasons that we said neither A nor B, instead of yes, you can do A, but you can't do B. It's a complicated and tricky thing to do A correctly. Now let's talk about B. You can never do B. B is absolutely prohibited. B was making a threat to bring an ethics complaint against the opposing counsel. And the reason you can't do that, oh, it looks like a poll has popped up. I'm just going to keep chatting, but make sure that you answer that poll if you need Kansas credit. So the reason that you cannot do B, that you can't threaten an ethics complaint against opposing counsel, is because our duties as attorneys in the state of Missouri to report the conduct of any other attorney, and in Kansas, by the way, to report the conduct of any attorney, which would include yourself, those duties are absolute. If the information that's set out in 4-8.3, which is the reporting duty, if you feel that the situation merits a report, you can't use that report as leverage because it's absolutely required. It's not something that you can bargain away. And If you are not intending to use, not intending to report the conduct regardless, well, then we go back to the same problem that you would have with A. You're not intending to make a threat or to actually put forward prosecution if the matter isn't settled appropriately. You're not intending to actually make a report, but the duty to report is absolute. Let's see here. Oh, perfect. I was going to say I may not be able to advance, but I can now that the poll's been taken down. So now another one of the things on this, these requirements were the use of the threat can't constitute a crime. I am not a criminal lawyer. I've never been a criminal lawyer, but let's look at how potentially something could be constituting a crime. There is a crime in Missouri of concealing an offense, and a person commits the offense of concealing an offense if one of the things is accepts or agrees to accept any pecuniary benefit or other consideration in consideration of his or her concealing any offense, refraining from initiating or aiding in the prosecution of an offense, or withholding evidence thereof. Or we may be getting into that, I'm not sure. There is also a Missouri case here that basically found a private citizen or entity cannot contract away his or her right to press criminal charges against the perpetrator of a crime. So are you impermissibly asking your client to contract away rights that they can't legally contract away if you want to engage in this type of tactic? Stealing is maybe another one, maybe another crime. You commit the offense of stealing if you appropriate property or services of another with or without consent or deceit or coercion. And we see property is defined as anything of value, whether real or personal, tangible or intangible. That's going to include a claim. Coercion is a threat, however communicated, to inflict harm, a threat to inflict harm upon the opposing party. I know we're getting kind of deep in the weeds here, but there's a possibility. An argument could be made. Some of these things do constitute a crime such that A would not be an appropriate thing to do either. So that's why we say neither A nor B. Even though the opinion technically says you can do A, we say, well, A probably isn't wise either. You may screw it up. You may run afoul of other laws that exist outside of the rules of professional conduct. So it's just not a wise negotiation strategy. Now, question 3. An attorney is leaving your law firm. The departing attorney has been lead attorney or assisted another attorney at the firm in a number of client matters. Regarding those client files, you being the attorney at the law firm that is being left, A, shall promptly give the departing attorney the files on which she was lead attorney but may retain the others. B, shall promptly give the departing attorney all files on which she was lead or assisting attorney. C, may retain all files in question because by contract they are firm property. Or D, shall comply with client directions on where to transmit the file. Take a second to make your selection here. And the correct answer here is D, shall comply with client directions on where to transmit the file. This is another Missouri informal opinion. What it tells us is that the file belongs to the client. Period, end of story, full stop. It does not matter that the client signed a contract with your law firm. It only matters what the client wants done with his or her file. And it's really hard whenever, and not all of the time, sometimes when an attorney leaves a law firm, it is sunshine and roses. But sometimes when an attorney announces that they are leaving a law firm to go to another law firm, there's animosity there. There's a need, both the firm that's being left behind and the leaving attorney feel some type of ownership interest in their client book. Both of them, it's a tug of war trying to keep those clients. We recommend, the bar plan recommends, thinking right now, before your firm finds itself in that situation, think right now about what the appropriate steps are if that happens and make a plan so that when it happens, you're not in the midst of that emotional tug of war. Because the reality is, if an attorney is leaving a firm and an attorney has done work on a matter, that attorney could potentially take the client. That client could potentially decide to stay with the firm, or that client could say, I'm done with both of you. I'm out the door. I'm going to give me my file. I'm going to a third party that wasn't involved in all this mess or what have you. Both the leaving lawyer and the attorney have a duty to notify the client of the change in circumstances in their representation, because it is a change, and get the client's consent to what's going to happen next. And whatever the client says should be done with that file and should be done with their representation. That is what has to happen. The client has an absolute right to decide who's going to represent them and who should get their file. Now, when you're coming up with a plan, a plan for what happens if an attorney is leaving the firm, these are some of the rules of professional conduct that may come into play. And honestly, this is probably a non-exclusive list. It's a lot of stuff to think about. And so you want to make sure that you're doing that correctly, not only because it's the right thing to do for the client, but also because there are a lot of ways you could potentially run afoul of the rules of professional conduct if you don't make the procedure now and follow it correctly at the time. I also want to point out that there was a case in Missouri where a Missouri attorney civilly, personally, was ordered to pay a former firm damages of over $500,000 and attorney's fees of over $200,000 related to the manner in which the attorney left the firm. The attorney was keeping client files after the attorney left, refusing to turn them over even after the client had said that they were supposed to. And civilly, the attorney was personally found responsible to the former firm for these amounts. Found that they violated the Missouri Computer Tampering Act because a lot of it was electronically stored information, a breach of contract, breach of duty of loyalty, and breach of fiduciary duty. So you want to be very, very cautious whenever these situations arise, that you are not only taking care of your ethics obligations and your duties to the client from a malpractice point of view, but also there could be personal civil liability if this is done incorrectly.
Hey, Whitney, we have a couple questions. Do you want to address them now?
Sure.
Okay.
Yeah, absolutely.
So the first one is, if the client wants the files delivered to them or to another attorney, does the firm have to bear the cost of that delivery, or can the firm tell the client to come pick up their own file?
So this is always a difficult question. Who bears the cost of photocopying, of all of those things? If it's talking about, and my answer is always, well, it kind of depends. If it is not difficult for the file to be mailed to the client, or it's not difficult for the file to be delivered, if we're just talking down the street or maybe even just across town, probably that's not going to be something that would be considered reasonable for the firm to try to make the client pay. If the client has instead said, well, I hired some attorney out in California who's some big high-priced so-and-so who also happens to be licensed in Missouri and Kansas, and I want you to ship it out there, overnight it out there. Well, at some point it becomes unreasonable, and that burden should probably fall on the client. It's not a definite and clear-cut thing, though, I will say. And so, like with everything, whenever I'm talking to attorneys who have questions like this, you probably want to, if you as a firm have a strong feeling about that, if you find yourself in that situation, talk it out with the client at the beginning of the representation. I hope that this wouldn't happen, but if for any reason we needed to send your file somewhere else to another attorney that would be representing you, do you agree that you would bear the cost or that you would split the cost, or whatever would be reasonable? Another thing is that just because something is stored in a certain way doesn't necessarily mean it has to be turned over to the client that way. If it can easily fit on a thumb drive, you can just shove in an envelope and mail out, and that would be probably pretty cheap postage. That's also permissible to send it that way. Again, so long as the client is on board with that. Did you say there were a couple of questions, Jen?
Yes, there's one more. So this question is a little different. If an attorney leaves the firm but does not want to take the files with them or the cases with them, and the example this lawyer gives or this person gives is they may be practicing a different type of law, for example. They can't take it with them. What are your duties under those circumstances?
Sure. So there's no indentured servitude in the law. An attorney is not required to take cases with them. Those duties would just be that the firm and the leaving lawyer would still have to notify the client about the change in circumstances, but instead of the three choices being stay with the firm, go with the leaving lawyer, or, get a third attorney, the choices then become stay with the firm. We'd love to still have you. You can even kind of play yourself up a little bit. We'd love to still have you. We've done a lot of hard work on this, whatever. You don't have to, you can be a little bit coercive in that situation, because it's not one lawyer versus another lawyer. It's one lawyer versus all other nebulous lawyers out there. But then they do have to also be told their second option, which is if you would like to find a different attorney based on this new change in circumstances, you certainly are welcome to. It's up to the leaving lawyer how much information you give about why they can't go with that attorney, but just a simple sentence that, that attorney is not going to be able to take your case should be fine. And if they say, well, I want to go with them, well, tough luck. That's not really an option going forward if the leaving lawyer isn't going to be in a position to take that case. You sometimes see that if someone goes to like a prosecutor's office or the public defender or something like that. So moving on to question 4, you receive an email from your client in a dissolution matter in which, in addition to describing his dissatisfaction with your representation, he states, and if I don't get what I want when this is done, she's going to find out what till death do you part really means. The client CC'd the email to his uncle who practices law in another state. You, A, shall report the threat to law enforcement. B, shall report the threat to counsel for the adverse party. C, shall report the threat to the adverse party. Or D, may report the threat to law enforcement if the client gives informed consent. Take a moment to pick your choice now. And the correct answer here is D, may report the threat to law enforcement if the client gives informed consent. Another Missouri informal opinion looking at this situation and explicitly pointing out that the bodily harm exception to confidentiality in the confidentiality rule, it is permissive, not mandatory. I think there are some states where it is mandatory, but it is not mandatory in Missouri, and I'm pretty sure it's also not mandatory in Kansas. It's permissive. So first of all of the others said shall report. It's never a shall report situation if there is a situation where there could be bodily harm. Also, in order for this exception to apply, where if you would like to, you may report it, in order for that to apply, you as the attorney have to reasonably believe that reporting it is necessary to prevent death or substantial bodily harm reasonably certain to occur in accordance with Rule 4-1.6b1. And comment 6 to that rule says harm is reasonably certain to occur if it will be suffered imminently or there's a present and substantial threat a person will suffer the harm at a later date if the lawyer fails to take action necessary to eliminate the threat. So let's actually look at what we're dealing with here in this hypothetical. He sends an email. If I don't get what I want, so already it's conditional. I don't think that means there's going to be imminent harm suffered, I don't think there's a present and substantial threat at this point that there will be harm suffered at a later date. So I don't know that we meet the imminence here for it to be a permissive report absent the client's informed consent. Another thing is she's going to find out what till death do you part really means. Well, is there a reasonable belief by the attorney that this is a threat such that disclosure by the attorney is necessary to prevent death or substantial bodily harm? Maybe this is the type of client who says stuff like that all the time. Maybe this is the third such email you've received this week where the client says something crazy like that, I'll punch their lights out. And the client never actually does any of those things. They're all just figures of speech, right? So it's possible that you could not have a reasonable belief, even if there is a statement like this where he appears to be threatening to kill his spouse. It's definitely not a funny joke. It's certainly off color, but is it the type of thing that would give the attorney reasonable belief. That's another thing to consider here. Your information as their counsel, that will factor into whether or not the belief is reasonable. So with all of this said, there does not appear to be here even a use of the permissive exception to confidentiality under the rule. So what do we go back to? Well, in order to disclose confidential client information, you have to get the client's informed consent if one of the exceptions to confidentiality in 1.6b doesn't apply, which it does not appear to apply here. That doesn't necessarily mean it wouldn't apply later. Maybe after the trial, he says something and you're like, oh my gosh, well, this is actually a threat. There's imminent harm. I need to step in. But I would say based on this email, it doesn't apply here. Also, I want to point out there's a red herring in this hypothetical. The client CC'd the email to his uncle who practices law in another state. That red herring was designed to catch anyone who thought that confidentiality went out the window when that happens. It doesn't. That would absolutely impact the privilege of that statement. It would no longer be privileged under the attorney-client privilege for discovery purposes, but it still is absolutely confidential, period, end of story. An attorney's duty to keep confidential information is absolute, absent one of those exceptions, and we don't have one here. Question 5, you accept a contingent fee matter after the client discharges her first lawyer. You, A, shall inform the client in writing that a portion of the fee may be due or claimed by predecessor lawyer. B, shall not charge client for negotiating predecessor counsel's fee if it does not increase the client's share. C, if you negotiate with predecessor counsel, shall obtain informed consent from client to any conflict from your dual roles. Or D, all of the above. Take a moment to make your selection now. And the correct answer here is B, all of the above. Now, this comes from an ABA formal opinion, but looking at rules of professional conduct, they look at the model rules, not individual state rules. They're very, very similar to what at least there is in Missouri. And what we see from this ABA formal opinion is that you, as an attorney, have to comply with whatever the requirements are of your state whenever you are converting a fee. You had it as a contingent fee. If you take it all the way to the end as a contingent fee, fine, it's a contingent fee. But if you've done a certain amount of work, but the contingency has not yet arisen when you cease working, your amount that you get is not just, well, I'm going to convert this to hours times rate, for example. That's one you see a lot. Oh, I converted it to hours times rate. It looks like I'm going to get, oh, look at that, 30%. Gee, man, that's what the fee was going to be. That's incredible. That's not how it works. In Missouri, we are a quantum merit state. Quantum merit is not hours times rate. It's an actual analysis to determine what would actually be the amount that would be equitable for the person who provided the services to receive them. Hours times rate may be a factor in determining what your recovery of the ultimate, or what your amount of the ultimate recovery should be, but it's not the be-all end-all answer. Clark versus General Motors is the Missouri case looking at what a quantum merit analysis looks like. So if you find yourself in this situation, having to do this type of analysis, and you are the attorney who has been left, or even if you're the new attorney coming in and you want to make a calculation as to what amount may need to be shared with the previous attorney, look at Clark versus General Motors. It's really informative about how to do these types of analyses. But you absolutely shall not, under any circumstances, if you are the new attorney coming in, just shrug your shoulders and say, I don't know, we'll figure it out. The other guy took it at 33%. I'll take it at 33%. I'll kick the other guy a couple of thousand. Client doesn't need to know. I mean, that is absolutely not what needs to happen. There needs to be a discussion with the client when they walk in your door and say, I fired my other attorney. Here's my file. I want you to come in and I want you to represent me in this contingent fee matter. Part of that discussion is going to be fee discussions about what amount may need to go to the previous attorney and how that's going to work out. I'm not going to go through all of these. There are so many cases that look at conversion clauses and strike them down and say, well, that's not how this works, or what have you, whenever these contingent fee representations end early, and what happens with those attorneys who did some work and, rightfully want to be paid for the work they did. So I'm not going to go through all of these, but I do want to point out this Pennsylvania case, Angino and Rodner v. Lesson. In that case, the contract actually said, and Pennsylvania is also a quantum merit state, the contract actually said, if we are discharged before this reaches its conclusion, then we are going to do it this way. I don't remember exactly how it was in the case, but it wasn't quantum merit, whatever they said. And the court threw it out, and they said, Pennsylvania is a quantum merit state. You can't get any recovery other than quantum merit. And the attorneys said, oh, but we talked about this with the client. And the client knowingly, fully informed, contracted away their rights to pay us in quantum merit and actually agreed they'd pay us this other way instead. And the court said, you can't contract around quantum merit. That's the standard, period, end of story. I don't care what you tricked the client into signing at the beginning of the representation. I'm being a little bit facetious, but that kind of is the way that the court looked at this situation and the way and what they said. So just, quantum merit, quantum merit, quantum merit. Be careful of your conversion clauses if they run afoul of that, because that is a problem under the rules and under your duties as an attorney.
Hey, Whitney, really quick. I think you just
Yeah.
answered this. Sorry to jump in, but we do have a question. The question was, if your contract says it converts to hours times rate, is that helpful? And I think you just answered that, but I wanted to make sure that that question was out there.
Yeah, I mean, it's helpful in that that may be one factor that's considered, but it's not helpful in that it's technically untrue, because it doesn't just convert to hours times rate, even if that's in your contract. No, quantum merit is still the standard. So if you want to include something like that in the contract, totally fine. But what you include in there needs to be quantum merit, or you're just putting in a contract provision that essentially is worthless. So question 6, you represent a corporation collecting on defaulted promissory notes. You're paid a flat fee on cases that result in a default. In contested cases, you're paid an hourly rate. The promissory notes provide for a percentage to be paid for attorney's fees. In many cases, this amount is more than your actual fee. The corporation collects and retains amounts in excess of your actual fee. You, A, are improperly sharing fees. B, are failing to be candid with the tribunal. C, both A and B. Or D, definitely A and maybe B. Take a second to make your selection. And the correct answer here is B, definitely A and maybe B. Now, I know we said current ethics issues, right? This is a Missouri informal opinion from 1996, not exactly current, but it still is absolutely good and true. And the reason we think it's helpful is this may be the type of thing, as we are now entering year 2 of a pandemic that has caused all types of havoc in the court systems, in the legal system, in people's financial situations. It's exactly the type of time when you may be negotiating for fee contracts with clients that may require some creativity. This might be the type of thing that could be suggested, maybe by the client, maybe even by you, trying to make yourself and your services look a little more attractive than the other shop down the street. So that's why we included it. Even though this is an old informal opinion, this is maybe the type of thing that might come up now. And what we see here is, first of all, that is improper fee sharing, period. Because you're stating that you are getting a fee amount, that amount is coming to you, and some of that amount is going somewhere other than you or your firm. So that is improper fee sharing. And the reason that it is not permitted is because of Rule 4-5.4, professional independence of a lawyer. Very first thing it says, a lawyer or law firm can't share legal fees with a non-lawyer. but it also may be an issue under Rule 4-3.3, which is the candor toward the tribunal rule, which says a lawyer can't knowingly make a false statement of fact or law to a tribunal or fail to correct a false statement that was made to the tribunal or offer evidence the lawyer knows to be false. So if you are putting forward evidence that your fee was X, and in fact, your fee was less than X, that is making a false statement of fact. And so it's potential that you could run afoul of, that this plan could run afoul of Rule 4-3.3 in those cases where, because it says in many cases the amount is more than your actual fee. In those cases where it is more than your actual fee, that would be a second violation there. It looks like we have another poll question that's popped up here. So make sure you answer that if you need Kansas credit. And I can go forward. I didn't know if I'd be able to go forward based on a conversation I had with Jen, but I can. So going forward to question 7. You represent client to recover damages for injuries received when they slipped and fell on a walking path in their apartment complex. While waiting for the client to finish treatment, you realize the statute of limitations has run on the claim. You, A, shall explain to client the impact of the statute of limitations, your failure to file suit, and other relevant facts. B, shall advise client that a valid claim for malpractice exists and admit liability. C, A but not B. Or D, both A and B. Take a moment to make your selection now if you're playing along at home. And the correct answer here is C, A, but not B. Let's go back and look at them. A, shall explain to the client the impact of the statute of limitations, your failure to file suit, and other relevant facts. That is yes. But shall advise client that a valid claim for malpractice exists and admit liability? Boo, no, you do not want to do that. Another Missouri informal opinion here, but I'm actually not even going to include any of that information here because we at the Bar Plan are very well versed in counseling and guiding, sorry, not counseling, but guiding attorneys about how to approach this situation. We call it the talk. How do you have the talk with your clients? There's been an error in a representation. You need to disclose it. How do you do that? Well, do tell the client about the status of the matter. Do tell them that independent representation may be appropriate for them. But don't discuss the value of the loss because you cannot give them any legal advice about the value of their claim against you because there's a direct conflict there. It's one that can't be consented to, by the way. There are some types of conflicts that can be consented to, but that can't. That's direct, that type of direct adversity. No, you can't give them that type of guidance. Don't admit liability. It is not ethically impermissible to admit liability. If you are itching to say the words to them, I committed malpractice, you can. You have the absolute right to do that. But it's not exactly wise from the perspective of your insurer who may be having to defend you and may be wanting to argue you did not, in fact, commit malpractice because of a nuance that maybe you weren't aware of. It's really hard to argue that when you have explicitly stated, I committed malpractice here, I have liability here. Third is don't attempt further representation in that matter without getting a conflict of interest waiver from the client. You have a direct conflict with the client relating to their potential claims against you, but you now also have a conflict with the client relating to your continued representation of them in the matter. I know that a lot of people don't believe that. I talk to a lot of attorneys who say, well, hey, our interests are aligned. If I can fix what I did wrong and then they don't get to sue me because I fixed it and they don't have any damages, our interests are aligned here. There's no conflict. But that's not true at all, because one of the things that client could do is say, okay, I'm out of here, give me my file, and sue you in malpractice. They don't have to let you try to fix it. They have no duty to allow that to happen. Also, how can you and that client's interests be aligned when you now have a strong interest in paying them as little as possible for a claim that they have against you? the way that our director of risk management puts it, you walk into a car dealership, you want to buy a car, the car dealership wants to sell you a car. Your interests are aligned. Obviously, they aren't. There's going to be a lot of discussion and butting heads there. So get that conflict of interest waiver because your interests are not aligned with the client you're representing when you committed an error, I promise. And even if you don't believe us, believe the rules of professional conduct and believe the ethics opinions that interpret those rules because they agree. Those things agree with what I've just said. Also, you need to make sure when you get that conflict of interest waiver that it clearly describes not only the things that the client is agreeing to have you continue to represent them in spite of, not only the conflict parts and the bad parts, but also make sure it describes the benefit to the client to keeping you as an attorney. So that's kind of a twofold thing. Number one, it lets you sell to the client what those benefits are. So long as they're factual, it's absolutely fine to put those out there. But number two, if you do down the road find yourself, unfortunately, in a malpractice action relating to this situation, and a plaintiff's attorney representing your former client, their now client against you in malpractice, wants to say, why in the world would the client have even agreed to let you keep handling this? Well, it's right there. I laid out all of the reasons that it was beneficial, and the client agreed and the client signed. So that's another reason to think about including that. I want to go through this really, really quickly because I have, 3 more questions to get to. But these are our recommendations for how to have the talk appropriately. Face-to-face meeting is best. The reason I say that is because you need to be able to see their face instead of just doing it over the phone. If you say, do you understand? And they go, yeah, that's the type of thing you need to be able to see so that you can know that the yeah was actually not true. But I know face-to-face COVID, it's hard. Video meetings, hopefully, will be able to do that same thing. Recommend having agenda, writing notes on that agenda of any questions that the client has, and then using that to confirm, document those conversations. Because once again, in this situation, you are looking potentially at a malpractice action that, depending on what it is, it may be certain to arise, or at least is more likely than the day before you committed this error, right? So being careful and documenting everything and every conversation you have is even more important now than ever if you find yourself in this situation. Question 8. Over the course of years practicing probate law, you've accumulated over 500 original wills for whom you cannot locate the testators. The wills, A, may be destroyed in a manner preserving their confidentiality 10 years after the conclusion of the representation. B, may be destroyed in a manner preserving their confidentiality 6 years after the conclusion of the representation. C, may be scanned and maintained by electronic media. Or D, shall be maintained indefinitely. Take a second, make your pick. And the correct answer here is D, shall be maintained indefinitely. Now, this explicitly comes from a New York State Bar Association opinion from last year, but analyzing requirements very similar to what we have in Missouri. This is the Missouri File Retention Rule. And what it states is that items of intrinsic value shall never be destroyed. So what that means is, a will being an item of intrinsic value, if you don't want to have to hold on to that forever, then either get it to the client at the end of the representation so that you aren't under the duty of holding it at all, or this doesn't prevent you from having to hold it forever, but it does prevent you from inadvertently not holding it if you're going to destroy the rest of the file. Keep a log of all of the files that you have that contain items of intrinsic value. So when you go to destroy a file, you can check it and make sure, hey, I'm going to pull out that stuff that is an item of intrinsic value. Now, I have Kansas attorneys, I know, with me as well today. And in Kansas, estate planning files have to be maintained indefinitely, period. You can never delete anything out of those. So especially the wills, that's true in Kansas too. Question 9. Oh, sorry, this is a long one. Conflict questions are long. You represent husband in a defamation action against his ex-wife related to statements made by ex-wife to investigators of Child Protective Services 2 years ago. While at her previous firm, one of your lateral hires represented ex-wife in the underlying investigation against husband. Ex-wife moves to disqualify your firm. You respond with lateral certification that I have absolutely no memory at all of any confidential information ex-wife may have provided to me if she did, and I did not retain any information, confidential or otherwise, that she may have provided. In fact, I doubt I could even pick ex-wife out in a crowd. I can attest without hesitation that I possess zero confidential information as to ex-wife as to any matter. The court, A, will disqualify you. B, will permit you to remain in the case because lateral can't pick ex-wife out in a crowd and doesn't remember any confidential information. C, will permit you to remain in the case because you did not knowingly represent husband as required by Rule 4-1.10, imputation of conflicts of interest. Or D, will permit you to remain in the case so long as lateral is screened. Take a moment now to make your pick. And the correct answer here is A, will disqualify you. This is a New Jersey case, but looking at imputation rules similar to what we have in at least in Missouri and Kansas. I'm unfortunately not sure about Arkansas, but I can tell you, at least in Missouri and Kansas, this is what the imputation of conflicts of interest rule says. If you're associated in a firm, none of the lawyers shall knowingly represent a client when any one of them practicing alone would be prohibited from doing so, unless it's based on a personal interest of the prohibited lawyer and doesn't present a significant risk of materially limiting the representation. Now, in Missouri and Kansas, no screening. You've probably heard about screening, setting up an ethics wall, or a lot of, firms have different terms for them. That's not allowed in Missouri and Kansas for attorneys. There is screening for some non-attorney professionals, but not for attorneys. In Tennessee, New Mexico, and Indiana, the 3 other states where the bar plan writes malpractice policies, there's screening that's allowed in limited circumstances. But Missouri and Kansas, it's a no. If the conflict is there, the conflict is there, and it is imputed, period. So what we recommend is that all attorneys keep a portable conflict of interest list, database, whatever word that you want to use, that's keyed into the requirements of 4-1.10, making sure that it includes the information that will be necessary to ferret out those exact types of conflicts that the attorney takes with them from job to job to job, hence portable. And that goes all the way back to the attorney's very first representation, because what we see here, it doesn't matter if you remember the representation or the person or any facts about it. The conflict exists by nature of the representations that occurred. And so regardless of what you remember, it's there and there will be disqualifications. You want to find that out first before you start taking on client representation. You don't want to get into that conflict situation that then the court has to kick you out of it. A reason that we recommend that the lawyers keep these for themselves instead of just relying on the firm to keep that information is the same. We talked questions ago about the what happens when a lawyer leaves the firm. It's possible when you leave your firm, if you go to them and say, hey, can I have a list of all of the conflict information for every case that I handled? They'll tell you to pound sand. They're not required to provide that to you. And they might view that as you trying to poach what they view as their client. Again, we talked about it's very problematic. Attorneys and butting heads about their proprietary interests in clients when they don't really own them. But that would be a reason that a law firm might be hesitant to share that information. And so that's a reason that you as an attorney want to protect yourself and protect the future firm where you're going to keep that information up to date for your own edification. Question 10. In 2019, the Kansas Supreme Court issued 21 opinions in disciplinary matters. Of those 21, the percentage that contained a violation of Rule 1.16, declining or terminating representation, was closest to A, 5%, B, 50%, C, 25%, or D, 10%. take your guess. I imagine it would be a guess. And I will tell you that the correct answer here is B, 50%. Now, the only reason we put this question in was just as another reminder that when you are closing up a representation, be it, leaving lawyer situation or, okay, well, we've done everything that we can and we're closing this down. Don't forget about your duties to the client. Half of the disciplinary matters in Kansas in 2019 had something to do with doing this, withdrawing from the representation and ending the representation in an incorrect way. Think about it like when you're at a restaurant, the server does an amazing job. And then for some reason, when it comes time to pay, when you're actually going to be making decisions about what you tip them, they're kind of disappear. Don't be that attorney. Don't disappear at the end and think, oh, I got all of that done. I don't have to worry about them anymore. Finish it out all the way. That is time, according to the timer that I have been keeping. So you guys got your ethics hour. Again, thank you. Thank you. Here's my email address. Reach out to me if you have any questions, and have a wonderful day.
Thank you, Whitney. I appreciate it very much. Take care. And everybody that's watching, thank you. This will end our webinar today. Have a great day.